Hello, YouTube. I'm Vince White. I'm an employment attorney. It is 9 p.m. and I have I should actually face my fingers towards the camera, two co-stars tonight. Aston the cat, who is sleeping at my feet, and we have Talisker Storm keeping me company. So it is 9 p.m., as we mentioned, and I have a video that must go live tomorrow at 9:30 a.m. So we are going to be answering a question from YouTube user What About It, who says, "Hello, I love your channel. I love your good taste. You are doing great things. You are kind. I'm doing aggressively mediocre things, but I'm trying really hard. My question is, if I have a good employment discrimination and retaliation case, what would be a good high and low amount for financial compensation as the demand when in mediation? Also, is the mediation process similar to an interrogation? Will the employer be allowed to interrogate me? Thank you." Okay, I'm going to answer the second part of your question first, and then we're going to get to the first part. You should never be interrogated during a mediation. No mediator worth her or his salt should allow you to be interrogated. Now, quick side note, somebody recently told me that the phrase "worth your salt" is racist. It's not, unless we're talking about Romans. So there's like an urban legend or like a historical legend, I guess it's not really urban, that like Roman centurions and legionnaires were paid in salt. That it was not the case, but they did receive as part of their daily ration some salt. And so the phrase came from the idea that, like, if you were a really crappy soldier, they would say, "You're not even worth your salt, like, let alone your pay or whatever. You're not even worth the salt they give you for lunch," right? That's where the phrase came from. I get why people might think it's racist because, like, Sub-Saharan, Saharan salt trade, Africa, Carthage, lots of things going on there. But generally speaking, if you have to work to make something racist, it's probably not as racist as you're saying, right? There's a lot of racism in the world, a lot. And generally when you see it, you know it, you smell it, you know, a little sniff test, you're like, yeah, that's racist, right? You kind of know, right? So if you have to do a lot of work to make something racist, you might be an asshole, right? Go find the obvious racism and address that rather than like the historical, took me 40 minutes to write a thesis on why this is racist phrase. Just a pitch, just a thought. You could address racism today that is clearly addressable rather than quibble about a saying. Just a thought. Okay. Sorry. The cat is just cooing at me. Guess she's happy. Okay. So you should never be interrogated at a mediation. Essentially, the only question you should be asked at mediation is, what do you want? And then you should have an answer. Now they might say, okay, why do you think you deserve that? That's a real question, and you might need to answer that. Or they might say, well, they're not going to give you what you want, but they will offer you this much. Will you take it? These are the questions of mediation, right? It's not, where were you on February the 13th, right? Like, it's not what we're doing at mediation. And if that is going on at your mediation and you're represented by counsel, you should talk to your attorney and say, why is this happening this way? And if you are not represented by counsel and you're having a mediation where you're being interrogated, you should leave. You should say, I'm not settling my case and now I'm leaving. I am ending this mediation. And then do so. Just leave, right? Mediation is not there for you to be questioned or interrogated. Mediation is there for people to sit around and talk about giving you things. Now, they might not offer you the things you want. That's entirely possible. I'm not even necessarily saying they should. I don't know what it is you're looking for, right? You might have a case worth $30,000 and you might want $30 billion. I don't know. But that's neither here nor there, right? Like, at the end of the day, mediation exists for people to say, you, plaintiff, have a claim and I don't want to litigate it out. So can we settle it? Can we come to terms? Can I give you something to get this done and over with? That's what mediation is. That's the purpose of mediation. It is to avoid litigation. Litigation is the process by which you are questioned, right? You are dragged into depositions and eventually into court where you'll be asked questions and people will try to fight with you and trip you up and make you look unreliable as a witness and all these things, right? Paint you as a liar, whatever they can. None of those things should happen at mediation. Now, I will say you might make your demand and they might slide across the table with a little piece of paper where you like secretly wrote a poem about murdering your boss. And they're like, do you still want 30 billion? Or you can be happy with 5, right? I don't know. And you might look at that little poem you wrote about like murdering your boss and be like, well, that's not going to play well with the jury, so I'll take the 5, right? I don't know. Just a hypothetical. But no, you should not be questioned at mediation, right? It's really just a conversation about, can we get this done? Now, I'm going to address the first part of your question, and I'm going to address it in 2 ways. One, you're asking, I'll read it again. What would be a good high and low amount of financial compensation as my demand when in mediation? Okay, so we have a playlist on how to value your claim, how to calculate your damages, right? Every case is different. Every claim is different. Even individual claims within the same case can be different. They can have different valuations. They can have different forms of damages in play. Here, I presume you're speaking about workplace sexual harassment, workplace discrimination. So you're going to have some mix in most jurisdictions of economic damages, emotional damages, and potentially punitive damages if you have a retaliation claim in play. And how many you have of each kind is going to depend on a number of factors. And you should really watch the entirety of that playlist because this is the most complicated part of employment law. Like, employment attorneys who are very, very good at their job sit around and argue within their own firms, within their own litigation teams about how to value cases, right? I routinely fight with people within my own firm about various valuations in various cases. Not in an angry manner, but they'll say, oh, we think this is the correct, valuation, and I might disagree. I might be like, well, I don't think you're properly calculating the emotional damages. This person is treating with a therapist, is speaking primarily about the events of the workplace, came into this with some serious emotional trauma that will probably not detract from the emotional damage of this case, but might present as something where we can convince a jury that they came in predisposed to be harmed by this behavior in the workplace, right? So I think you should increase the emotional damages component of your demand, right? And these are conversations that employment attorneys have. There's no sure thing answers when you're calculating damages. That's why I'm annoyingly saying watch the playlist, because the best that we can do, we, the cat, the scotch, and I, the best we can do is tell you some things to think about. And that's annoying. That's an annoying answer. I wish I could just be like, yep, I'll do a damage calculation for you. Let's go. But that's going to take somewhere between 1 and 3 hours. And I'm going to have to delve into a lot of really private parts of your life. And I can't do that for people I'm not representing because, 1, it's super invasive and you should be doing it with your attorney. But 2, I don't have 1 to 3 hours to help you. I just can't, right? I'm not, YouTube user, what about it? I'm not saying this to you. I'm saying this in general. This is to the world. I wish I could just do a damage calculation for everybody who called me up. But let's face it, it's now 9:16 p.m. and I'm still working. So it's not going to happen. I'm not going to be able to do that, right? But I do want to highlight something that's potentially more useful that you spotted that was really, really clever. So the annoying first part of the answer is watch the damages calculation playlist. The second part is you said, what's the good high and low amount? And what you actually said, I'll read what you actually said because I changed the wording a little bit. What would be a good high and low amount for financial compensation as a solution when in mediation? So I like what you're saying there because you're saying the solution is the ultimate result. What's going to get this done? What is going to, you're viewing mediation as a problem, which is exactly how the defendant is viewing it. They're viewing mediation as a problem. How do we fix this problem, right? And there is a solution, potentially, right? And the way you stated it, high and low, the high and low amount of financial compensation is a good way to look at it. And I would say this to you. You go in at your high amount, but it can't be so high that the defendant says, you probably couldn't win that much. Like, why are you asking us for more in settlement than you could realistically win? Right? This is the classic thing that happens all the time. You'll have people, do you ever look at like a classified ad for a car sale? And somebody's got like a 1996 Honda Civic that's been broken into repeatedly, had homeless people living in it, doesn't have any tires, and it's running on 2 cylinders. It's got 300,000 miles on it, and the paint job was changed by an aggressive man-child to matte black, and he like put a little tin can on the muffler to make it real loud. Nobody wants that car. Nobody ever wants that car, except somebody might have to buy it. So it's valued to take into account all the things wrong with the car, right? But somebody who's going to sell it might put out a classified ad and be like, this is my pride and joy. I'm selling it for $80,000. Would you buy that Honda Civic from 1996 with 300,000 miles on it and a laundry list of things wrong with it for $80,000? I wouldn't, right? And so you don't take that person seriously. You don't have a serious negotiation, right? If they start at 80,000, you're like, this person's a effing moron. I'm not going to negotiate with them, right? But if they had started at, say, 5,000, well, you might say, listen, nobody's going to pay you on God's green earth 5,000 for that car. But I would give you 2,000 because I need a car. I need to get to work. Money's tight. I need that car. And I am the only person in the world that will give you 2,000 for that car. And because that person started at 5 instead of 80, you might now have a conversation. There might be a negotiation back and forth. You might buy a car, you might not. But you had a conversation that was meaningful about people trying to get the deal done, right? So too in mediation, do you want your high number to be high, but not so high that it kills the conversation? And a good rule for this would be, if you're asking for more at mediation than you can realistically hope to win, everyone's going to laugh at you. To quote Adam Sandler, everyone's going to laugh at you. Because why? Why would the defendant pay you more than you could probably win? There's no guarantee you win. If you want to win at all, you've got to embrace all the risk of trial. Go all the way through trial and hopefully win. You hope you win. You know very well you could lose. And even then, if you win, you might not win as much as you hope to win. So why, at mediation, would you demand more than you could realistically hope to win? These are the questions of our time, right? So you identified really astutely that you should come in high, but you should be careful with that high. You should tailor it to be high in the sense that it's going to help you get eventually to your lower figure, which we'll talk about in a moment, but not so high that it kills the conversation. And someone in the comments right now is like, well, I don't want to settle. Yeah, then don't. Then don't. No one's telling you to settle. But then just don't go to mediation. Like, if you're going to go to mediation and ask for $30 billion on a case worth $80,000, guess what? You're wasting your time. You're wasting your time. You're wasting everyone's time. And it's not a smart move. And you can say, well, I didn't want to settle. Okay. There's reasons why you might do that, right? You might want to run litigation costs for your employer. That's possible. It's probably not that meaningful. Mediation is not a huge amount of hours for the employer. So that's something you can say is what you want to do, but how real is that? right? You could say you went to mediation for a fact finding. You wanted to find out where they're at. You wanted to find out what kind of evidence they might present to you to force you to settle. Okay, maybe, but if you're starting at 80 billion or 30 billion, whatever it is, you're not going to find out as much because they're not going to take you seriously. Right? Those attorneys are just going to say, well, this is a waste of time. This case is worth 80 grand. Like, if this person tries this case and wins, we think this person's going to win 80 grand. So why would we pay them 30 billion? Right? Why are you asking for 80,000 for the Honda Civic? Nobody's got time for that. They're all going to laugh at you, right? I'm not telling you to go small. I am telling you to have a grasp of what you could actually hope to win and be guided by that, right? So that's how you set your high number. Your low, this is a more emotional number. And everybody gets really emotional about the high. The high is positional. The high is a signaling system, right? Your high number, think of it as Morse code, right? Everyone's signaling at the beginning of a mediation. Where you start, they're not going to come in and say, oh, you would like 30 billion? Yes. No one's going to say yes. No one ever just says yes, right? It's not a thing. So they're going to come in, they're like, well, you're at 30 million. Cool. We're at $250. Right? Like, it's signaling. So don't get emotional about the high number. But do be aware of the emotionality of the low number. Because the low number, this cat just walking in just sauntering through my screen. Oh, yeah? Okay. The low number is what you determine would actually be worth it for you to be done with the case, right? The high number is just signaling. The low number is what lives in your heart of hearts. It's going to be like, okay, if I look at this case and I look at the risk of trial, I look at the pain and difficulty and work involved in litigation, and I take all that into account, and I take into account that I might not get my money for somewhere between, 6 to 3 more years, 6 months to 3 years of litigation. And then if I win big, they're probably going to appeal, and I might wait 2 more years on appeal. And if I take all of that into account, what dollar figure would then make me feel whole? What would be the right number for me, not actually me, but you, the actual person who went through attacks on your very identity, right? I mean, that's what workplace discrimination is. And that's really what workplace sexual harassment is too, in a way, right? Someone's trying to attack you on a very core level. So you experience that, and you're taking that and the concept of being made whole for that, and thinking about how you feel about the risk and the weight and the work and the trauma of trial and all these things, and arriving at a conclusion. What would I actually settle for? And what I don't like to see is someone figuring that out at mediation. Because at mediation, there's a whole bunch of people trying to influence you. There are defense attorneys who want bad things for you. They want good things for their client and bad things for you. They want to cut you a check, but they want that check to be small, right? And the mediator, all too often, doesn't give doesn't give a hoot about you. Mediator only wants the case to settle. And if it settles for 50 cents or 50 billion, it's all the same to the mediator. It's all the same, right? Most mediators, and I have videos on this channel about good mediators and bad mediators. You know, good mediators care. They have an eye for fairness and things of that nature. Bad mediators don't. And bad mediators outnumber good mediators 5-1, easy. So even your own attorney, right? Your own attorney could be trying to influence you. And it's hard to know if you're with someone who's just like, take the settlement because she or he wants a quick buck, or if someone's saying, take the settlement because you got some holes in your case. You got some things you're going to have trouble proving. You got some parts of your story that don't really hang together that great, right? Or you can't keep your story straight. Your story could be amazing, right? We can look at the documents in your case and know you were wronged horrifically. But god damn, your ability to tell that story, it ain't there. Sickest thing about people who can't tell their own story, they often don't know it. When they say things, they hear the magic, the opera of what they went through, right? Everybody else hears wah, 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 wah. And then on September, wah, wah, wah. Oh, I forgot, wah, wah, wah. And they can't, and they're like, oh, I forgot the thing from June. What? What are you talking about? They're not in time order. They're getting facts wrong. The facts don't match the documents. The facts don't match the clock. The facts don't match the count. They can't keep anything straight. But when they tell the story, symphony, heartstrings, right? Like they are playing the harp. Oh, everyone hanging on their word, and that's how they feel. That's how they feel, right? I routinely talk to people who are educated, talented, wonderful folks who have next to no ability to recount a story. Like, that is a highly specialized skill. People do not understand how difficult it is to convey a story that you have lived. If you're conveying a story you heard, you can parrot the person who told it to you. And that is often what we do. That is what an oral tradition is. We hear a story, and then our mind retells the story as similar as possible to the way it was told to us, because we found it compelling. And it was compelling because that story was originally put together by someone who's good at telling stories, right? But when you live a story, no one ever told it to you. You lived it. So when you compose the story, if you don't know how to tell a story, it's not going to be pretty. And you can work on that with your attorneys, but part of working on it is realizing you have to work on it. And it can be really hard to have a conversation with a client and tell them, okay, I know that you think, you talented, highly educated, highly effective human that you are, I know that you think that when you say these things, they're a story. But what you're actually doing is regurgitating facts at random with no temporal order of any kind, no timeline, no structure, no character building. We don't care about anyone involved. We don't know the setting. We don't really empathize with how you felt. And we're not really sure any of this happened because none of it is going forward in a way that can be easily corroborated or in a way that our linear human minds can really get a hold of. This is very common, right? So I'm way off topic. It's the scotch. So I'm going to end this, but my point here was take all of that into account when you're calculating your number that you would actually accept, right? And be brutal with yourself, right? But don't do it at mediation. Don't do it when people are trying to persuade you. Do it when you have time to think, to talk to your trusted circle, to have conversations with your attorneys. And if you don't like the conversations with your attorneys, great. Check the conversations with your attorneys with other attorneys and with your trusted circle, right? And workshop stuff. If the attorney's like, listen, you cannot tell your story. You are the worst witness in the world. I'm not saying you should believe that attorney, but I am saying you might want to go to your trusted circle, your friends, your families, your advisors, and say, hey, am I a good storyteller? They're like, yeah, totally, yeah. Okay, so you think that I should risk everything and go on the stand and tell my story and win this case, even if they offer me hundreds of thousands of dollars. Do you think I should go tell my story, right, trusted advisor? And then they might not be like so effusive. They might be like, Well, I mean, you do have some trouble telling a story, right? That's why you do this before mediation. You get this opportunity to really be brutal to yourself, to talk things out, to think things out, and arrive at your actual number that you would actually accept. And I'm not pressuring you to take a lower number. You might really go through this process and be like, I should shoot for the stars. I love that for you. But it is a little rare. It is a little rare. So take it into account. Go into mediation with your high number where you want to start, and go into mediation with an extremely clear idea of what would actually get this done for you. And then don't feel like you have to give up on that number, right? Be confident. You arrived at that number because you feel the strength of your case and all the factors we just talked about have led you to that calculation. Great. If you did a good job, stick to it. Absolutely. If your attorney doesn't like it, too bad. Try the case. Right? I mean, I don't know what your deal with your attorney is, but hopefully it includes representation at the hearing or at the trial, whatever you have, the arbitration, whatever you have coming up, right? And if you can, great, roll the dice. Let's go to the big show. Let's make it happen. We didn't get to the low number, the number that would actually get this done, so this mediation has failed. It did not provide a solution. It did not solve the problem before us, which is this case, this wrong that was done to you. And so, forward we go. What about it? I went super long. This is a 27-minute video. I'm going to have to listen to it to make sure it even makes sense. But I hope it answers your question. If it doesn't, I will track the comments down below and try to provide follow-up answers. If it was helpful, like, subscribe, comment down below. It helps me to help more people just like you. Remember, almost everybody works. Not everybody wins. Be smart out there.